Good evening to all of you. In murder cases, the investigation should be perfect and not perfunctory. And if any point which goes to the benefit of the accused, definitely benefit of doubt will be given to the accused. This is what happened in Madras High Court, right? Even though the prosecution wanted to prove the case, of course, in the lower court they were successful, but in the higher court, that is in Madras High Court, so many lapses have been found. So as defense advocates, we must be able to know the lapses and then only we will be successful in the cases. So for that purpose, I am making this video. So you can refer the case as Mayandi versus the Inspector of Police, Thirukurumgandi Police Station, 2020. Right? So you can see the case in Criminal Law Journal, page number 1089, volume number 127, and part number 1485. This judgment was given by two judges bench, Mr. Raja and Pugalendi, on 18/9/2020. Last year, the judgment was given. What are the lapses? First of all, let us know. So before that, let's go to know the details of the case. So this incident took place on 27/2/2014, around 5:45 p.m. Right? On that particular day, the deceased, Mr. Mahajan, he informed his wife, Swarnam, to get ready to go to the temple because it was Shivaratri day. Prior to that, there are differences between him and his niece, and not niece, is accused, okay, some relative. So Mr. Mayandi is the sister's son. So sister's son of the deceased. Actually, the deceased has got two daughters and he performed their marriages and now he is living happily. So Mayandi wanted a portion of the property since he has no male issues. He asked his uncle, the deceased, to share with the property, for which the deceased refused. So this Mayandi has got grounds against him, and on that particular day, when this Mahajan came to Subaya Nadar Hotel to have tea at about 5:45 p.m., the accused came on a motorcycle number TN72B8853 and abused him in Filna language and whipped out an Aruvad, that is almost a broad sickle, just like sickle type of weapon. Of course, in Tamil Nadu, they use it as a weapon for murders and also as a weapon for cutting grass, and for agriculture purpose also they use them, multi-purpose. But with that, he inflicted about 7 or 8 injuries. And when the people gathered there and shouted and cried, then this man went away on his motorcycle. This is the thing happened. Immediately, actually, one person, he wanted to inform Thirukurumgandi. He wanted to inform the same to the wife, Mrs. Swarnam, but she did not lift the cell phone. Ultimately, his son-in-law, who has come to his house for Shivaratri function, he was traced and he was informed, and all of them took the injured, very badly injured person to the government hospital in Palayam, Kotak. But it was a bit delay. By 7:30 or 8, we could reach the hospital. By the time, the hospital authorities declared that he was brought dead. So they brought Swarnam to that place and she gave the complaint about actually she narrated the motive portion also about the differences between the accused and the so-called deceased and the property disputes. All these things they have been explained. So the police registered a case in crime number 26/14 under section 294B and 302 IPC. 294B is abusive words, not necessary. 302 IPC, registered in the Thirukurumgandi Police Station. So the inspector is a lady by name Nagamani. So she has visited the spot on the same night. She conducted an observation report on the next day, that is on 28/2/2014. She conducted inquest right from the morning 8:45 a.m. and after that she went to the body for post-mortem examination and the rituals were done. Then on 3/3/2014, the so-called accused, he straight away has gone to the police station and he surrendered himself. Right? The police interrogated him in the presence of VRO and he gave a confession. Basing on the confession, according to 27 of the Evidence Act, the motorcycle and also the Aruvad, both of them were recovered. The charge sheet has been filed. Right? With this, it's over. But what happened is, on someday on 2/7, that is almost after 4 or 5 months later, on 2/7/2014, there was a fire accident in which the motorcycle was burned. Right? Anyway, so they could not produce the motorcycle before the court. Right? Anyway, basing on the evidence, 19 witnesses were examined, and the main witnesses they turned hostile. But still, basing on the evidence of the police officers and the PM certificate and all that is circumstantial evidence, the judge at Tirunelveli, additional district and session judge Tirunelveli, he gave judgment on some date 2016 on 6/2/2016 and convicted the accused under section 302 IPC and imposed life imprisonment, also a fine of 1,000. So agreed by the judgment. Now he came to the High Court on appeal. Now, as regards the appeal, the High Court has found the following stunning points. So lapses in the investigation, right? So the first point is that the injured person was shifted in a private ambulance to the government hospital Palayamkote, but neither the driver of the ambulance, or at least the number of the ambulance was not noted, neither the driver or cleaner or attender of the ambulance, they were examined and they were cited as witnesses. So they were not cited as witnesses. This is the main point. Second, the doctor who attended on the deceased, he was not examined by the prosecution. Third point, the case of the prosecution is that the accused came to the scene of offense on a motorcycle. The motorcycle was not produced. Of course, they have said on 3/7/2014 there was a fire accident, but the electricity people, they were examined. Mr. Thirukurumgandi Durai, he is a staff of the Tamil Nadu Electricity Board. So he said there was no power cut on the particular day at the relevant point of time, and all the street lights were properly working. Finished. So the alibi or the allegation of motorcycle burning by fire accident is not proved. That means they are not able to produce the sufficient or cogent evidence, right? So, and actually no witnesses were examined to say that the accused came on a motorcycle. So the witnesses whose names were mentioned, they turned hostile. So no independent witness was examined to say that this man has come on the motorcycle, right? Another scientific. So as for the scientific evidence, even though the bloodstained Aruval was seized and it was sent for forensic examination, then no evidence. So it does not contain any blood stains. So no blood stains were present on the weapon recovered, right? So this weapon was recovered from a particular land. The owner of that land, he was not examined and he was not cited as a witness. So with all these lapses, this shows the failure of the prosecution to prove the case beyond all reasonable doubt, and therefore benefit of doubt has gone to the accused. Now the Honorable High Court has allowed the appeal, and so now the accused is discharged or acquitted of all the allegations under section 302. See how pathetic it is. The failure of the police. So you have to catch these points. Important points are: number one, the ambulance driver, the ambulance number, they were not noted. Second, the motorcycle, even though it was burnt, no cogent evidence was cited. Number three, even though the bloodstains, the weapon was seized, it does not count because he inflicted 7 times or 8 times gaping injuries on the body. So no bloodstains were present. That means they have concocted this weapon. They have falsely planted this weapon. So when all these things are there, how can you say that the case should end in conviction? Luckily, incidentally, the judge court, he has convinced, but in the High Court, they have looked out a threadbare, they have discussed and ultimately acquitted. The appeal was allowed. So this will be a good case for you in murder cases particularly. Definitely it will be useful, and please go through the judgment and enrich your legal knowledge. Thank you very much.